Court directing the first and second defendant by themselves and or through its officials or anyone acting on its behalf to reinstate the claimant on claimant's job as senior inspector with all the benefits / arrears of salary in the tune of 88,000 naira, each camp allowance of 150,000 naira, passing out parade monitoring allowance of 15,000 naira, and promotion, and which otherwise would have been due to the claimant from the date of dismissal. Number 8, the sum of 100 million naira as general damages for breach of fundamental right of the claimant. Number 9, cost of this action. Number 10, 10% post-judgment interest until final liquidation. Number 11, alternatively, an order of this honorable court converting the said dismissal to retirement with all statutory retirement benefits. The first and second defendant upon service of the originating processes filed a notice of preliminary objection on 13th of April 2018, seeking to strike out and or dismiss the matter, and file a statement of defense on 10th of December 2018. However, the notice of preliminary objection was overruled on the 20th of June 2018. The first and second defendant earlier filed a statement of defense on 19th of June 2018, but was struck out at their instance. Meanwhile, the third defendant, with the leave of court, filed his amended statement of defense on 18th of September 2018. The claimant thereafter filed a reply to the defense of all the defendants. The case of the claimant from his pleadings is that he was employed by the first defendant in 2006 and served at various positions in some different local governments of some states of the Federation. Claimant also averred that he enjoyed promotion and was never found wanting until July 2018, when the ordeal that led to his dismissal on 16th October 2017 began. According to the claimant, as an inspector covering Goyo West local government, he was confronted and queried over a serving corps member in Joko, Victoria, who was not at her place of primary assignment. He explained that she called in with an emergency to go and attend to her sick father, but did not take permission from the principal of the school where she was serving and did not seek his permission either. According to the claimant, the said corps member was later induced by the inspection and monitoring team of the first defendant to indict the claimant by stating that she had an arrangement with the claimant to stay away from her place of primary assignment and that she paid the claimant to cover her while she was away. The claimant stated that he was coerced to write an apology letter confessing what transpired a return of his letter of promotion to grade level 10, which has been held down on ground of vacancy. Claimant also stated that he was not invited before any panel and no fair hearing was given to him before his dismissal, hence this suit. The case of the first, second, and third defendant. The fact as elicited from the defense of the defendants are that the claimant as a local government inspector knew that no corps member is permitted to use initials but signature on all documents. That when initials were seen on the register from the place of primary assignment of Victoria, the first and second defendant had to make inquiries where investigation revealed that the claimant was receiving 12,000 naira monthly for 7 months from the said corps member for her to stay away from her place of primary assignment. That some payments were made via the corps liaison officer, while some were paid through the personal account of the claimant. The first and second defendants stated further that claimant made an apology admitting the allegation during investigations by the staff management committee settled by the first and second defendant, and that the corps member, after the first denial, later willingly confessed to the arrangement she had with the claimant without coercion. The court is then urged to dismiss the suit of the claimant as fair hearing was accorded the claimant at all material times. Trial. On the 8th of April 2019, trial commenced with the claimant testifying as CW1, where he adopted his statement on oath dated 6 September 2018 and 17 January 2018 respectively, and tendered 34 documents as exhibit as follows. CW1 was cross-examined by the defendant and discharged after re-examination. On the 2nd of January 2020, Salamatu Wada, DW1, testified on behalf of the first and second defendant and adopted her sworn statement on oath dated 10th of December 2018 and tendered the following 12 documents. DW1 was cross-examined by the third defendant and the claimant as well. She was then discharged after re-examination. Njoko Victoria Oluti testified on 2nd of November 2020 as DW1. She adopted her statement on oath made on 25th June 2019 and was cross-examined by counsel to the claimant and discharged after re-examination. The matter was then adjourned for adoption of final written addresses. Submission of the first and second defendants. The final written address of the first and second defendant was filed on the second day of December 2020. Bear leave of court granted on the 16th of May 2025, wherein a single issue for determination was tried by counsel to, and I quote, whether from the state of the pleadings and evidence laid by the parties, the claimant was given fair hearing before his dismissal by the first and second defendants. According to counsel, it's not in dispute that the claimant was a senior staff of the first defendant, that he was accused of conniving with a core member to evade her national service by extorting money from her, which amounts to serious misconduct. That 2 committees were set up to investigate the allegations against the claimant, while the staff management committee verbally invited the claimant to appear before them, and the claimant made a verbal confession before the then State Director, Mrs. Ataniwa EE, before he reduced it into writing. It's a submission of counsel that by Chapter 4.3 1 to F of the NYSC Conditions of Service, of the NYSC Conditions of Service 2013, where a staff is accused of a serious misconduct, he must be referred to an appropriate body, which in this case was the staff management committee. And the committee invited the claimant verbally, which he admitted in private at 7 of his deposition, but stated that he was not allowed to say anything. Counsel argued that by the various exhibits tendered, the claimant's actions showed connivance, negligence, and intention to sabotage the NYSC scheme. That by exhibit NYSC 1, DW1 had a regular signature, but when she got to her place of primary assignment, the signature suddenly changed to an initial V. Meanwhile, the claimant is aware that core members are forbidden from using initials as signatures. There's only DW1 who signed the monthly payment voucher, which had initial V, to the knowledge of the claimant. Counsel also submitted that the claimant during cross-examination admitted that he was not denied any benefit due to him on his promotion, and the promotion letter predates the confessional statement of the claimant, that this clearly undermines the claims of the claimant that he was threatened with denial of promotion to elicit a confessional statement from him. It was argued that DW2 testified that she had an arrangement with the claimant, paying him 12,000 naira monthly for 7 months to avoid service at her place of primary assignment, that payments were initially made through the co-liaison officer who received 2,000 naira, a letter directly into the claimant's account, and this contradicted the claimant's defense that the money was a loan or payment for co-members magazine, as the magazine for 2015 Batch B only commenced in July 2016, whereas payments were made in April 2016. Counsel submitted on the issue of fair hearing that by the provisions of the NYSC Conditions of Service, the defendant issued 2 queries to the claimant on grounds of gross misconduct, which he equally responded to, and gross or serious misconduct attracts dismissal as punishment. Counsel cited the case of Imonike and Unity Bank of Nigeria, Azenabo and Bayero University Kano, Natal and Aqua, Yusuf and Union Bank of Nigeria PLC. Counsel went further to submit that the claimant was accorded fair hearing prior to his dismissal, and an employee who replied a query in writing cannot complain of lack of fair hearing, citing Section 36 of the 1999 Constitution and the case of Inajoko, Inakoju, and Adeleki, Meyako, and Itodo, Imonike, and Unity Bank PLC, Supra. In conclusion, counsel maintained that the claimant's dismissal was justified as he was accorded fair hearing and the evidence overwhelmingly prove his involvement in misconduct. Thus, his claims lacked merit. Submissions of the claimant. Claimant's final submission, filed 11th of November 2020, contains the following 3 issues for determination. Number 1, whether the claimant has proved his case against the defendant in support of his reliefs, having regard to the totality of evidence before the court. Number 2, whether the defendants have proved the allegation of serious misconduct against the claimant, which warrant his dismissal. Number 3, whether the defendants have complied with the conditions of service in dismissing the claimant on allegations of serious misconduct. Counsel submitted on issue 1 that the uncontroverted fact placed before the court without any counter from the defendant shows that the claimant has successfully proved his case that Mrs. Atamenwan and Mr. Matthias Kona were not part of the committee for promotion and discipline because they are not qualified by law, that the claimant was not the author of the register and did not have any agreement with the state, Ms. Victoria Njoko, to cover her up, but that he only gave her a loan of 10,000 naira, which she repaid with 2,000 naira meant for magazines for NYSC magazine, or for messages for NYSC magazine. It was stated that exhibit JMJ 30 was never disapproved by the first and second defendant. Neither Mr. Matthias Kona, who induced CW1, nor Mrs. Atamenwan, who gave a condition to CW1 to meet before his promotion letter would be handed over to him, were called to disprove his claim. Counsel submitted that the claimant has proved his claims against the defendant by oral and documentary evidence to show that his right to fair hearing was infringed upon, that the claimant informed the court that he did not appear before any panel, and the principal actors who perpetrated his illegal dismissal were never brought to court to give evidence because if the principal actors were called, their evidence would go against them, which amounts to his holding evidence as held in the case of Obenwon and State. So the further submission of a counsel that the claimant has proved his claims by referring to exhibit 19 and 32, and that DW1 under cross-examination admitted that the claimant denied all the allegations in exhibit 23, that the claimant was a senior staff before his dismissal, that exhibit NYSC 5 and 6 did not recommend the dismissal of the claimant, and that the claimant never appeared before any committee, that this admission was corroborated by DW1. Counsel urged the court to resolve this issue in favor of the claimant. On issue 2, counsel submitted that the first and second defendant called 2 witnesses and documentary evidence, which are quoted by admissibility test, and the third defendant did not call any witness, but rely on the documents and testimonies of the first and second defendants. According to counsel, the documents tendered by the first and second defendant did not meet up with the admissibility test, as they are not tendered by the makers. That exhibit NYSC 1, which is the file of DW1, was tendered via DW1. That exhibit NYSC 1, which is the file of DW2, was tendered via DW1, and DW2 never made reference to the documents, and no foundation was made there too. That exhibit NYSC 2, which is a report by Godwin Otuku, was tendered through DW1 Salamu Tuada. Exhibit NYSC 3 to 9 was photocopies tendered without proper foundation. The tendering of all these documents through DW1, who is not the maker and without proper foundation, amounts to documentary hearsay. Counsel cited Section 84 of the Evidence Act and the case of Kakon and the state, Belgore and Ahmed, Mak and Abubakar, Ekpezu and Oti. Counsel continued that the statement on oath of DW1, especially paragraphs 11, 16, 17, 26, 28, 30, 32, and 40, offend section 115 of the Evidence Act, as they are incompetent in law, and defective in substance, and ought to be struck out, as the defects cannot be cured. Citing also section 113 of the Evidence Act and the case of Elias and Ecobank PLC. Counsel urged the court to strike out the said paragraphs of the statement of DW1, as one cannot put something on nothing and expect it to stand, as said in the case of VP Industry Limited and Coca Industry Limited. Counsel contended that the signature of DW1 at the deponent's page was scanned from the computer, as she did not send, thereby making the statement on oath incompetent. This shows that the rest of summary and statement of claim of the first and second defendant are not accompanied with any statement on oath, and the same is defective. Counsel rely on the case of Henry and Union Bank PLC. Counsel submitted that the third defendant filed a statement of defense with a witness statement on oath, but did not fill any witness. Rather, the third defendant relied on the witness of the first and second defendant. According to counsel, the third defendant has no evidence before the court, and it is tried that pleadings are deemed abandoned when they are not supported by evidence, as held in the case of Popola and Bambejin. On issue 3, counsel on issue 3 that assuming there was any recommendation to dismiss the claimant, it should have been done according to the laid down conditions of service of the first defendant, especially as provided under Chapter 2, dealing with appointment and recruitment, and Chapter 4, which deals with discipline. The dismissal of the claimant within an outline prohibitions contained in Chapter 4 of the conditions of service shows that dismissal was null and void and of no effect. Counsel equally submitted that the appointment of the claimant was one with statutory flavor. Therefore, his termination or dismissal thereof must be in line with the statute. Counsel cited the case of Oni and Governor of Ekiti State. Counsel contended that from the time of the response to the query up to the time of the claimant dismissal, it was 6 months, 8 days, as against the stipulated period of 3 months, and by exhibit NYSC 5 and 6, the categories of persons who sat to look into the accusation of the claimant lacked the capacity to do so, and the claimant was a senior staff on grade level 10. Therefore, the burden lies on the first and second defendant to prove the allegations against the claimant. Counsel refer the court to the case of Pezu and Oti. According to the claimant's counsel, corruption and extortion are serious offenses which require proof beyond reasonable doubt, and it's not enough for the defendant to rely on the public service rules. Counsel refer the court to particularly section 03305 and 04306 of the public service rules, section 11135 sub 13 of the Evidence Act, and the case of Tajudun and FIRS. Counsel urged the court to expunge exhibits NYSC 1, 2, 3, 4, 5, 6, 7, 8, 9, and 11 for being documentary evidence, that they are inadmissible documents, having not been tendered by the maker, who should have been cross-examined on the document. Counsel cited the case of Ngogu and Atuma, Genga and APC, Ilyasu, Seburu, and the state. Counsel also urged the court to discontinue the entire final written address of the first and second defendant for being argued in error. The submission on exhibit JMJ 33 and 34 was at variance with the condition of service of the first defendant, and the claimant denied the confessional statement in exhibit 19 and 20, especially as DW1 informed the court that the claimant denied the allegations raised against him. In concluding, the court is urged to grant all the reliefs of the claimant from the date of his dismissal. Decision of court.
As the court pleases.
Having carefully considered the pleadings filed, the evidence adduced, and the submissions of the respective counsel, the issue I will determine is whether the claimant has proved his case to be entitled to the reliefs sought. Claimant's case before the court is that he was employed by the first defendant in 2006 and worked in different roles across various locations, receiving promotions over the years. However, in July 2016, he was accused of conspiring with a serving co-member, DW2, to allow her to avoid her primary assignment in Oju, Benue State, in exchange for a monthly payment of 12,000 naira. The claimant initially denied the allegations, but later claimed that the then state director of the first defendant intimidated him into admitting guilt in return for his promotion, later to grade level 10. Claimant has asked for 11 reliefs. 4 out of the reliefs are declaratory in nature, namely seeking to validate his dismissal on the basis of violation of his fundamental right to fair hearing and undue influence, particularly concerning his coerced letter of apology and other procedural irregularities. He also argued that the entire disciplinary process leading to dismissal disregarded his right to fair hearing, rendering it null and void. Provisions under sections 132, 131, 132, and 132 of the Evidence Act state that responsibility to prove the existence or non-existence of a fact rests on the party who will lose the case if no evidence is presented in their favor. This principle was affirmed in Adeyemo and Akintola, while the court ruled that the plaintiff bears the burden of proving a loss occurred or that damages incurred. A similar instance was taken in Kuku and Olusoga, and Unwavu and Okoye, reinforcing the principle that the party asserting a claim must provide evidence to substantiate it. In proving his relief, the claimant testified on his own behalf and tendered 34 exhibits as evidence. He argued that the disciplinary process outlined in Chapter 4, Sub 3 of Exhibit JMJ 33, National Youth Service Corps Condition of Service, was not properly followed, particularly concerning his right to appear before a disciplinary panel. Additionally, he maintained that as a senior staff member, the disciplinary committee that investigated the allegations against him was improperly constituted. He further contended that the 3-month time frame required to finalize disciplinary proceedings was not adhered to. The claimant acknowledged only that he had been issued 3 separate queries on different dates, exhibit JMJ 19, 21, and 25, to which he responded by denying any knowledge or involvement in the absence of the core member from her assigned place of primary assignment. Now, let me refer to Chapter 4.2b of Exhibit JMJ 33, which defines serious misconduct as follows. B, serious misconduct. This means a specific act of very serious wrongdoing and improper behavior, which is inimical to the image and proper administration of the scheme, and if investigated and proved, may lead to dismissal from service. Any of the following offenses is a serious act of misconduct: 1, 2, 3, 4, corruption, extortion, and unquote. Similarly, Chapter 4.3 also states as follows: disciplinary procedure. Due process shall be followed in instituting disciplinary measures against an erring officer as follows. A, the officer shall be issued with a written query detailing the alleged offense and prescribing a time limit within which the officer shall respond in writing. B, the officer shall acknowledge the receipt of the query on a slip to be attached to the query for that purpose. C, if the officer works in the same station where the query is issued, he shall respond to the query within a period of time not exceeding 3 days from the date of receipt of the query. If, however, the officer works in a station other than that from which the query is issued, he shall respond to the query within a period of time not exceeding 7 working days or receipt of the query. D, the alleged offense shall be investigated by an independent team vis-a-vis the response of the officer. E, the officer shall be allowed full access to all official documents he may require to make his defense. F, the officer shall appear before the appropriate disciplinary committee for hearing, and if he so desires, cross-examine the witnesses if any. G, the officer may elect to be represented by a legal practitioner, provided that he gives the committee not less than 5 days notice in writing. H, except where the alleged offense involves crime, all disciplinary cases shall be concluded within 3 months from the date of receipt of the officer's response to query or expiration of the time limit for the response, whichever is earlier, and a letter of indictment or exoneration issued to the officer. I, if an officer is alleged to be generally inefficient, he shall be issued with 3 consecutive warnings before the provisions of subsections A to H of this section shall apply. If the relevant committee deems it fit, the officer's appointment may either be terminated or he shall be required to retire from service if he satisfies the conditions for retirement. J, the report of the investigation panel shall be placed before appropriate personnel committee/board, which shall, based on the report, affirm or review the decision as it deems fit. All cases of gross misconduct shall be proved beyond reasonable doubt. If any doubt exists, it shall be resolved in favor of the officer. Unquote. Now, the principle of fair hearing entails the right to be heard in one's defense. In Gukas and Just International Breweries Limited, the court held that an employee whose employment is terminated for misconduct after having issued a written query and given the opportunity to respond cannot later claim a denial of fair hearing. Similarly, in the case of Omonike and Unity Bank PLC, His Lordship, Rosvival, JST then, emphasized that where an employer accuses an employee of misconduct through a query and allows the employee to reply before making a termination decision, the requirement of fair hearing are satisfied. This means that issuing a query later constitutes fair hearing, as it provides the accused the opportunity to know the allegations against him and respond accordingly before any disciplinary action is taken. The claimant as TW1 admitted in paragraphs 30, 36, and 43 of evidence that he was issued with queries dated on 7 June 2016, another query dated 3rd August 2016, and a third one dated on 3rd March 2017. And he responded to all the three queries, even though he contended that he was not invited to any panel. The principle of law remains established that facts admitted require no further proof. See the case of Pina and Meangwa, Adeleke and Jolason. Adeleke, Jolason and Bamboy, Tooks and NPA. The importance of fairness and due process in disciplinary hearings cannot be overemphasized. And the key points that need to be highlighted are that the employee must be informed of the nature of the charge against him to enable him to prepare for his defense, and he be given the opportunity to state his case. It is evidently clear and must consider that the claimant was issued queries, which he answered. It's also evident by exhibit NYSC 6 that the claimant admitted to the committee of his guilt and pleaded for leniency as the first offender. Similarly, by paragraph 38 of the claimant's statement on oath, the claimant admitted appearing before the investigation committee, but alleged that no question was put to him, nor was he allowed to talk. See paragraph 38 of the witness statement on oath. To me, the claimant having been issued queries and appeared before the disciplinary committee cannot say that he was not accorded fair hearing. Claimant also contended that his apology statement was made a return of his promotion letter, which was withheld since 2013, but was only released to him after he was coerced into making the apology statement, admitting the allegation between him and the DW1. The above contention does not sit well with me. The circumstances leading to the making of the apology statement do not actually show that the apology was done under any threat. The statement does not have any connection with the claimant's promotion. I believe it was done by the claimant out of his own free will. For the claimant's contention that the 3-month time frame required to finalize disciplinary proceedings was not adhered to, I will simply say that this contention will only come into play where the allegation does not involve crime, as provided by Chapter 4.3 H of Exhibit 33. In other words, where the allegation involves a crime, then the 3-month time frame to finalize disciplinary proceedings will not apply. For the composition of the disciplinary panel, it was contended by the claimant that as a senior staff member, disciplinary committee that investigated the allegation against him was improperly constituted. The provisions of Chapter 2.1.1 states as follows. Senior Staff Committee. A. The Senior Staff Committee, SSC, shall be made up of heads of department. The Director General shall be the chairman. C. The committee shall handle the appointment, discipline, and promotion of officers on SDL 07 and above, unquote. There's no doubt that the claimant was on grade level 10, and his employment with the first and second defendant was governed by the conditions outlined in Exhibit JMJ1, appointment letter, JMJ 33, conditions of service, and JMJ 34, public service rules. The evidence before the court clearly establishes that the claimant's appointment has statutory protection. And when an employment contract is regulated by statute, or when conditions of service are derived from statutory regulation, the employee holds a legal status beyond that of a typical master and servant relationship, as established in the case of Ms. Bau and Ejibo local government. The only valid way to terminate such an employment is by strictly following the statutory procedure. Any termination that deviates from the prescribed legal process is null, void, and ineffective. Statutorily protected employment typically applies to positions within the public or civil service of the federal, state, or local government, as well as government agencies, institutions, and parastatals, where civil service or public service rules are applicable. See the case of Kwara Polytechnic and Shitu, University of Ilorin, and Abbey. Furthermore, it is a well-established legal principle that a public officer facing allegations of misconduct can only be lawfully dismissed if the employer adheres to the prescribed statutory procedure. Failure to comply with this process renders termination invalid. See the case of Futayola, Yola, and Mayowia. By the provisions of Chapter 1.3, head of department is defined as a director of a department at the scheme's national headquarters on court. The provisions under Chapters 1, 2, and 4 speak for themselves. The modalities, among others, under Chapter 4 are that the alleged offense shall be investigated by an independent team, and the officer shall appear before the appropriate committee for hearing. Then the report of the investigation panel shall be placed before appropriate personnel committee, which shall, based on the report, affirm or review the decision as it deems fit. It can be observed from Exhibit NYSC 5 and 6 that the persons who sat as members of the management disciplinary committee were not heads of departments as provided under Chapter 2.1.1a. In Exhibit NYSC 5, which is the Staff Management Committee report dated 11th of November 2016, 5 members seem to be assistant directors, while in Exhibit NYSC 6, which is the report of the committee, while in Exhibit NYSC 6, which is the report of the committee to review the disciplinary case, it is only 2 persons out of the 5 members who were assistant directors. In Psychiatric Hospital and Management Board and Ejitaga, the principle of law was reaffirmed that a public body in exercise of statutory powers must act only within and must not exceed or act outside those powers. In the light of the foregoing, therefore, I'm of the opinion that the first and second defendant have not complied with their conditions of service in dismissing the claimant by putting in place the appropriate committees to investigate and review disciplinary cases against the claimant, even on the face of his statement apologizing for his involvement in the alleged offense. See the case of Haruna and University of Agriculture, Makodi. Accordingly, claimant's case only succeeds in part. And since the claimant has, in his alternative relief, asked to convert the dismissal to retirement, then it is hereby declared and ordered as follows. Number 1, a declaration that the purported procedure through which the first and second defendant reached the decision on the allegation of misconduct against the claimant without placing the appropriate disciplinary committees is irregular and void. Number 2, a declaration that the notice of dismissal dated 16th October 2017, which was issued by the first and second defendant to the claimant, is null, void, and of no effect, having been issued without following the proper procedure as contained in Exhibit JMJ 33. Number 3, an order setting aside and nullifying the purported disciplinary actions reached and taken against the claimant as contained in the first and second defendant notice of dismissal dated 16th October 2017. Number 4, it's also ordered that dismissal of the claimant is set aside, but is converted to retirement from today, and the claimant shall accordingly be paid all his accrued salaries, allowances, and statutory retirement benefits.
As the accomplices. My Lord, I sincerely appreciate the court for the industry put in this particular case. I listened carefully how my Lord has decided this matter with merit, and I commend my Lord so much for the industry. Thank you, my Lord.
Thank you, Mr. Bemba. Okpe?
Yes, my Lord.
My Lord.
Yes.
Hello?
Yes, Okpe.
My Lord.
I can hear you.
We are most grateful for these erudite judgments.
Thank you.
Well done, my Lord.
Thank you. It's converted to retirement, so you can go and...
Yes, I will notify the management. I will, my Lord.
That's if you don't want to appeal. But next time, okay, please, when you are constituting any disciplinary committee, and look at the conditions of service. It said directors in the case of senior staff. It said directors, not any other person.
Very well, my Lord.
Yes. So we'll be sending the judgment and the yes, and the
most grateful, my Lord. I will convey the message.
Okay, thank you so much. We will be sending the judgment to Makodi Division.
Thank you, my Lord.
Yes, to enable
okay,
them.
My Lord.
Yes, force them to you. So I thank you so much, Mr. Bemba and Okpe. Yes, I thank you so much. I appreciate
my
you.
Lord, as well.
I'm wishing you happy.
Thank you, my Lord.
Weekend in advance. Yes.
Thank you, my Lord.
You, my Lord.
Thank you. So in the absence of any other thing, I write that will be all for today. Thank you.
As accomplices. Thank you, my Lord.
Thank you, my Lord. Bye.
Thank you. Okay, bye-bye. Thank you.
Thank you, my Lord.
Thank you.
Mrs. Okpe.